And good evening. My name is Richard Lee. I'm a lawyer with Lee Associates. I'm joined tonight to present Introduction to Condominiums by Bilal Mirza, who's part of the legal team at Simpson Waggle Law. Bilal is also he also volunteers and chairs the education committee at CCI Golden Horseshoe chapter. And also joining us is Michelle Joy, Director of Condominium Management at the Hamilton office of Wilson Blanchard. Michelle also volunteers much of her time with CCI GHC's Finance Committee and conference committees. Before we go further, I want to thank the sponsor. CCI is a not-for-profit organization. It relies on its on sponsorship, membership to a degree to put on sessions like we're doing tonight. Tonight's session is sponsored by Lee Associates, which is my firm, and Wilson Blanchard Property Management. Wilson Blanchard, as some of you might know, has been around for a long time, 25 years. They just celebrated. They're a full-service management company providing services in physical property management, financial reporting services, community management, and preventative management. Also, before we get into the topic, I just want to go over some upcoming sessions that we're doing. Some are, the first one's very exciting. We're doing one on insurance. Riding the rising insurance wave. It's starting, this is a condo talk session. The condo talks are not intended to be formal educational courses per se. It's more casual, where we want to talk through a topic. And as we were organizing this one, we found that we were talking about part 2 and then part 3, and who knows where it's going to go, because you could take almost any small topic of insurance and spend an hour or 2 or 3 dissecting it and discussing it. So we're going to start this one on the 18th. These are lunchtime sessions, the 18th, 12 to 1. Then part 2 is on the 1st, 12 to 1. If we need a part 3, it'll be the week after, etc. Very exciting about that. And another condo talk session, which we have scheduled for the 15th, deals with board authority and battling apathy. You know, it's called that owner did what? Again, looking forward to that. Sometimes there's a misunderstanding about what boards can and can't do and what the role of owners is in that. The last one I want to talk about is our upcoming advanced directors course. What you're going to be hearing about tonight is an introductory level course. It's meant to be an intro to the advanced. And in the advanced, we take what we're doing tonight and expanding on it. Instead of over one evening, we're doing 8 evenings this time. Again, to try and keep it manageable. It's a fabulous course. It's the one I typically send my staff to because I think it is just really good. And then lastly, we are going to ask for your feedback on tonight's course. So we do like to know how we're doing, what we can do better, what you'd like to hear about, etc. So tonight's introductory course. I like to start with what I call the condo paradox. Condos have been marketed for years as carefree turnkey living. You buy, you move in, and there's absolutely nothing to think about or take care of. And we all know that that's not quite true. We're not told that the community needs a government. Somebody's got to step forward and put themselves in service of others. We're not told about the individual personalities that some condos take on and why those evolve. We're not told about the politics that come into play and why it's always necessary as owners to stay involved in the direction of the condo. We're not told what's going to happen if nobody wants to be a director. That question's coming up more and more. Education, or the lack of education, it's being identified as a major contributor of conflict within condominiums. And as directors, I'm assuming many of you are directors tonight, as you're putting yourselves in service of your community, you've got to be asking the question about how do you know what you don't know? And that's what we're trying to do a little bit tonight. We're seeing the value of education get traction finally. CCI has been doing this for almost 40 years, always focused on the education of directors and owners since 1982. The government has finally gotten into this. November 1, 2017, less than 2 years ago. I think this course tonight will go farther than what the government currently offers. And again, the advanced course is is absolutely fabulous. So what is a condo? A condo or condominium really just describes a method of communal ownership of property. And it can be almost anything, you know, residential, commercial, mixed use, retail. There can be condominiums, you name it. It's really a way of how you live together and how you divide that property. Typical condominium, you've got units and common elements. The one exception to that really are common element condominiums, which don't have units per se. They've got pottles, parcels of titled land. I'll be describing that in the next couple of slides. In a condominium, when an owner buys into a unit, they're buying a share of the entire property. It's called the common interest. And if you look at the back, towards the back of your declaration, you'll see something called the proportionate share of common interest, and that sets out that amount that you own. We've got what's in a condo. We've got units, of course. These can be residential, parking, storage, garage, commercial, retail, industrial, telecommunication, hallway, stairway, almost anything can be unitized. Common elements, the common elements is everything except the units. And the as a subset of common elements, you've got exclusive use. You know, if you look at this diagram here, so you've got the entire property, and again, when you buy into a unit, you get your proportionate common interest. Down the middle, we've got the unit. Everything that's not the unit is common element. And then we've got the backyards and the front yards, which are exclusive use. If they're exclusive use, they're still part of the common element areas. Condos also has assets, cash, investments. Sometimes it owns a super suite, guest suite, etc. The condo could own parking and storage units, maybe some equipment, furniture, electronics. A condo can own, acquire, encumber, dispose of real property, so it does have that right. And then there's also shared facilities. I usually share shared facilities as a subset of either assets or units or whatnot. But it's important to consider this. Shared facilities could be a rec center, a driveway, visitor parking. Again, almost anything can be shared. It's usually shared with another property, not necessarily another condominium. The various types of condominiums. I usually like to ask here, what is a freehold condominium? I find the term freehold is really misused in condominiums. Freehold means, it only means that you own the land, and that's to be compared to leasehold. They're the two. You've got freehold, which could be standard, vacant, or common element condominiums, and then leasehold, which stands on its own, and basically the condo is sitting on leased land. In a standard condominium, you've got the entire property, you've got units. This is obviously a townhouse sketch, and a common element road, front yards, backyards, etc. Probably some visitor parking at the end of that road. As a somewhat subset, you've got a phased condominium. Many times a condominium will be built over time, and historically we've seen shared facilities agreements join maybe two buildings, two properties or whatnot. Another way of doing it is to actually develop it as a phased condo, where a developer will first create the condo with a portion of the units and common elements, and then bring in the next bit, and that will be folded into the existing condominium by way of doing an amendment to the declaration and description. It means you're only dealing with one condominium at the end of the day, which has got its advantages and some disadvantages, but usually is a good thing. Common element condominium, I mentioned this earlier. The only part that's the condo are the common elements. So again, taking that same diagram, you might have a park, you might have a roadway, you could have a golf course or a ski hill or almost anything as part of the common elements. Then you've got what were the units in the standard condo, and in a common element condo, these are called pottles, parcels of titled land, and they're not actually part of the condominium. They're tied to it. When you buy into a pottle, you're buying a share of that condominium, but the condo stands outside of it. So everything to do with the pottle is on the individual owner. Vacant land condominiums, again, that same diagram, but you'll notice nothing's built. Typically, it's left up to the owner to build, or it could be the developer who will build for the owner. The big difference with a vacant land condo, you might still have units built eventually. They might be to plan, but the big difference is there's no ability in the declaration to shift responsibility for maintaining and repairing the units to the condo. Similarly, with insurance, the entire insurance obligation on the units is shifted to the unit owner. Then lastly, leasehold condominiums. The reason why these become necessary is you sometimes have a landowner that cannot sell the land. Think about a university, or it could be a church or whatnot, and the land has covenants attached to it that does not allow that entity to sell the land, but they might be able to lease it. And if they can lease it, they can build you can build a leasehold condominium. They're supposed to be more affordable because there's actually no land component. The lease is amortized over anything from 40 years to 99 years. They're supposed to be cheaper. I'm not sure if I've seen that. And then in a sense, the leasehold condo is automatically renewed for 10 years at the end, unless there's notice to terminate at least 5 years before that. I'm not, in my practice, I haven't had a leasehold condominium terminate yet. They're still relatively new. They only came into effect 2001. On that, any questions yet on that? Michelle Aberza, anything come up? If not, I'll let
nothing yet.
Nothing yet. I'll let Bilal take over.
Hey, thank you, Richard. Right, so I'm going to talk today about the Condominium Act, and I'm also going to be talking today about directors' responsibilities and governance obligations, and in particular, I'll also speak briefly about the various documents that comprise a condominium and how they interplay amongst each other. With respect to directors' responsibilities and governance, what's important to note is that there is legislation in place in the Condominium Act, which requires certain basic parameters to be satisfied for the condominium to act through the board. In particular, there's Section 27, which requires the affairs of the corporation, condominium corporation, to be managed through the board of directors. So it places the onus upon the directors to manage the affairs of the corporation. And how does the board go about carrying out its functions? It's through board meetings. Section 32 of the Act then requires that all business of the corporation is to be transacted through properly constituted board meetings, which have the requisite quorum. Some of the other things that are important on the point of governance and responsibilities are also the duties of the board of directors and the corporation. So with respect to the objects of the corporation, Section 17 of the Act sets out that the object of the condominium corporation, and of course that flows into the obligations of the board of directors, is to manage the property of the corporation and the assets on behalf of the owners of the corporation. The corporation and the board also has a duty to take all reasonable steps to ensure that the owners and the occupiers comply with the Act, the declaration, the bylaws, and the rules. And I'll talk about these documents in a few slides. And there's also an obligation to control, manage, administer the common elements, as I mentioned. Another aspect of the board itself is to determine how does the board run its meetings and then also who can be on the board. So those are two important questions I'll touch upon as well. So a board meeting under the requirements of the Condominium Act, Section 35, this can also be supplemented through the bylaws of the corporation. Requires that the meeting of the board of directors be authorized through a quorum of the directors. A written notice has to go out to all the directors at least 10 days before the date of the meeting of the board of directors. This can be in person, through registered mail, or other means permitted in the bylaws. And it should specify the time and date of the meeting and a brief and general description of the business to be transacted at this board of directors meeting. Who can be on the board of directors? So there are certain requirements in the act, and also the bylaws of the corporation may supplement or add to this. But essentially, a person has to be at least 18 years of age, can't be an undischarged bankrupt. They should be able to manage property under the Subsidiary Decisions Act. Recently, with the amendments that have come in to the act, there are requirements that directors will also attend training. There's a training that's offered to the government organization for mandatory training that has to be satisfied. It's under the Bill 106 that came in, Richard mentioned previously. And this has to be within 6 months of the election or appointment of the directors. It's valid for 7 years, and then existing directors have 1 year to complete this mandatory course. The directors also are required to provide certain disclosures when they are to be elected, or when an election for directors is being contested. So some of the things that they have to disclose, this is also by law, there's a form that has to be filled out and circulated. They have to disclose whether there's any direct or indirect involvement in any legal proceedings in relation to the condo corporation, if they've been convicted of any offense under the Condominium Act, if there's any direct or indirect contract with the condominium corporation in which they are a party to. So just to avoid conflict of interest, of course. And if their unit has been in arrears for more than 60 days. So some of the requirements is for the directors, what their eligibility criteria and qualifications are under the Act. And like I said, these can be supplemented in your bylaws. So it's always important also to look at the condos bylaws to see if they have any additional requirements over and above these. Moving on, so on the matter of, sorry. Okay, condominiums documents. Any questions so far on the governance, etc.? Okay. So in relation to the condominium documents, there is a hierarchy that has to be followed. At the top is the legislation, the provincial legislation, which is the Condominium Act. That governs how a condominium is created, what the different kinds of condominiums are, as Richard alluded to just now. What are the requirements to create a condo, and once it's established, what are the different ways in which it should manage and be administered. Once you've created a condominium, you of course would have a declaration and a description. I'll talk about that. And then there are bylaws, rules, and policies, and I'll touch upon those as well. So the declaration. So what the declaration does is it legally creates the condominium. It's the document which, once registered with the registry office, it creates the unique condominium, and it's given its own particular, let's say Wentworth Condominium Corporation number 500. So it creates its distinct entity. It will also set out certain basic requirements which are mandatory under the Condominium Act. So it must have in a schedule set out what are the percentage ownership interest for each unit, and then that also correspondingly addresses how much or what proportion does each unit owner contribute towards the common expenses of the corporation. It will also set out what are the exclusive use common elements which are attached to each unit. So some units may have an exclusive use backyard or a patio or a balcony, etc. So those have to be set out in the declaration. That's where you will look at to determine which particular unit has which particular exclusive use common element attached to it. Boundaries of each unit will also be set out within the declaration. So you're looking at the declaration to determine what is the legal limitations and spatial restrictions of each unit. A declaration may also have statements with respect to the common element expenses and what comprise the various things that are added up to come to arrive at the common expenses that the corporation has. Restrictions on leasing, sales of units. There might be restrictions on occupation or use of units. So these are other things that we commonly see in declarations, but there's some basic mandatory requirements that I mentioned have to be adhered to. The description is a document that goes along with the declaration, and it's basically a survey which sets out in a diagrammatic form what a condominium looks like. It's much like the document that Richard was showing to you in the earlier slides, but of course it has many other aspects to it. Normally it comprises of multiple sheets, and it sets out in a lot of detail the survey or the plan which shows what the condominium looks like. Both these documents are registered together to actually create and get the condo going. So they are the documents which essentially establish the condominium. The other document that's also registered on title is the bylaw, and there can be several bylaws for each corporation, so you should be looking out for numbers. And then sometimes when you have newer bylaws, and some of these may repeal older ones, so you should always be looking at all the registered bylaws to determine which are in play and which have been repealed. But what does a bylaw do? So a declaration, like I said, is basically setting out what is a condo. A bylaw, on the other hand, describes how does a condo go about doing its business. So the first bylaw normally is called the organizational bylaw. Each condominium has it, and it sets out various things like how do you hold meetings, like I said, who can be a director, what are the quorum requirements. There would be a long list of things which it addresses with respect to the daily administration and management of the condominium and the various affairs of the corporation. There are also requirements in the legislation which require certain aspects to be covered within bylaws. So the governing bylaw, as I said, is one most prevalent bylaw that you would see in almost all condominiums. Other bylaws that we come across often are the borrowing bylaw, which basically authorizes the corporation and the board to borrow on behalf of the corporation. Standard unit bylaws are fairly common now. They would set out the basic structure of the unit for purposes of insurance. Occupancy standard bylaws may restrict the number of occupants in a condominium unit, and these are becoming more and more common as well. So these are just some of the bylaws that we see. How are they approved? So you need, in order to pass a bylaw, you need at least 50% owner consent to create a bylaw, repeal a bylaw, or amend a bylaw. Moving on, sorry for that. Rules. So rules essentially set out how do people live at a condominium. They are rules for, let's say, daily living. They may deal with standards of behavior in a condominium, noise requirements, restrictions, uses of various facilities that a condominium offers. The requirement in the Condominium Act is that the rules have to be reasonable, in contrast to the declaration requirements, as I mentioned before. There is no requirement that these be reasonable. So you're always looking at the standard of reasonableness when you're looking at rules. And many condominiums would go in a lot of detail setting out the various aspects of day-to-day living, which these address. It's a more of a living document. It's easier to amend as time goes by because the board of directors can pass rules, amend, repeal rules. They become effective on the 30th day after they have been mailed out or they've been served to all unit owners, unless the unit owners requisition a meeting at which they have to be they have to be voted upon then to be passed or not passed at that point in time. So they're easier to amend. For that reason, they reflect the living reality of the condominium much more, of course, than more stringent documents like a declaration, etc. may allow for. The requirement in the Condominium Act and the purpose of the rules is to promote the safety, security, or welfare of the owners and property, and to prevent the unreasonable interference of the use of the property. So these are also important documents that you should be familiar with and look and review just to determine if they, of course, from a director's perspective, if they accord to the current reality of the condominium and if these require any updates, because these, as I said, every few years you're looking to review them to make sure that they're up to date. They also have to be consistent with your declaration and bylaw. So in that hierarchy that I mentioned before, because they're more towards the end of that hierarchy, you have to ensure that they follow and adhere to and are consistent with the documents above it, like the bylaws, the declaration, and of course the Condominium Act. Policies. Policies are documents which set out procedures and processes just for the inner workings of the condominium and some of the things that the board may just put out certain documents which are not very formalistic or legalistic in nature, but they're good to have because they may provide a framework for dealing with things. I'm sure, Michelle, you come across these often dealing with boards. What are some of the policies that you've seen?
Yeah, so I would say the most common that we see, definitely, again, I think you see more policies, my experience as anyways, is in high-rise buildings as opposed to the townhouse sites. So common policies, elevator booking policy, party room rental agreement / policy, most recently, COVID-19 policy, mask, face covering policies,
Right.
There's lien, corporations have their lien policies for collections. So there's quite an array of policies that can be implemented. One thing that I would say that I see often is for boards is don't make a policy on something that needs to be a rule. And I think the lawyers can speak to the policies are not very enforceable when it comes to issues with residents. So that's just a little thing I come across often that I wanted to throw in there.
That's a good point, Michelle. Of course, because these are just for procedure and just to ensure that there's some framework for people to follow and the board to follow, and that they're not binding us.
Can I jump in there a little bit?
Go ahead, Richard.
I had this actually come up this week, where I was drafting a mediation procedure bylaw for a condo, and the board came back and just said, this is really long and dry. Can we not just either not do it or do it by way of some informal policy where we just agree on how to do it? And the bottom line is, if you're going into mediation, or if you've got a dispute that goes to mediation, parties aren't agreeing to anything. So if you've got a policy, the policy cannot be enforced.
Mm-hmm.
Policy is just for consistent practice at the board level.
Right.
Right. So there's always the risk of dumbing things down. Whereas if it's done by way of bylaw, which the Act allows you, the Act directs that is a practice that can be enforced in that way. There's a reason for the formality.
Right. That's an excellent points you both make, because there's, as I said, there's a hierarchy to these documents. So some of these documents, of course, are not even like the policy in particular. It's not a legally binding document. Of course, the declaration, the bylaws and the rules are binding on the unit owners and the corporation, and also the Act, in fact, requires the directors to ensure that there's compliance. So there's an obligation upon the board of directors to ensure that all unit owners, in fact, comply with the declaration, bylaws and rules, and of course the Condominium Act. So it's in fact the opposite for those legally binding instruments. That's something to be aware of. So I'll just move on here. Before I talk about enforcement, just some of the other documents and some of these Richard also mentioned. Shared facilities agreements are some documents that I come across. They're also in that hierarchy of documents that a condominium should be looking at, directors should be looking at to determine rights and responsibilities. Reciprocal easements and agreements are also documents which are often commonplace in condominiums, and you should be aware of those as well. And I just mentioned enforcement. So like I said, there's an obligation on the corporation and the directors to ensure compliance. And if there's a breach by unit owner, there's usually a step-by-step process is taken. You're supposed to try and ensure compliance through perhaps engaging property management, and if it's not, of course, not a serious or a grave breach, and then you take a step-by-step approach. But the act itself also provides that you can go through mediation, arbitration, and then if it's just still not addressed, you go to court. And there's several provisions in the Condominium Act which permit the condominium to ensure enforcement and compliance as well. Any questions so far on these topics? I'm sure we have the chat box there, and I'm sure Richard and Michelle are also monitoring that. I'll move along in my slides here. So the next section that I will cover here is unit owner meetings. There are three kinds of meetings, and I'll touch upon all three, which are in the legislation as well. There is the annual general meeting, which is, of course, the one which is mandated, legally required. Then information meetings and requisition meetings I'll also briefly talk about. So the annual general meeting under Section 45 sub 2 of the Condominium Act, the board of directors is required to hold the annual general meeting. Once the corporation or the condominiums established, within 3 months of the declaration being registered or the condominium being created, the turnover meeting happens. And then each year going forward, you have to ensure within 6 months of the fiscal year end date, you have your AGM. This, of course, is in the current circumstances. There are rules in play which alleviate and provide some leniency on those rules with COVID. But under general circumstances, normal circumstances, the law is that 6 months from the fiscal year end date, you're to ensure AGMs are properly held. What does an AGM normally deal with? So the annual general meeting normally would have, as part of the process, a financial report from the auditor. The auditor normally is present at the meeting and talks to the financial position of the corporation, gives a report. The appointment of the auditor normally also happens on an annual basis at the meeting. There might be discussions about the budget. Of course, advanced copies are circulated to all unit owners. There might be an election of the directors if any terms are up. So that's something that may happen at the AGM. And there might be other business or that's discussed, any matters that are raised by unit owners. And normally you would also see a report from the board on issues of significance to the corporation, perhaps from the president or property management as well at times. Only matters that are in the meeting agenda can be, of course, discussed and voted upon at a meeting. So that's something to be aware of with respect to what the agenda is important for that purpose. Requisition meetings are, on the other hand, meetings which are not, something that's periodically required. They're, as the name suggests, requisitioned by the unit owners. At least 15% of the unit owners have to requisition this meeting or any meeting in writing. There's prescribed forms, and there's provisions in the Condominium Act which require certain basic requirements for the requisitioning of the meeting by unit owners, for all unit owners to get together and hold such a meeting. It should be in writing. It should also state the nature of the business, and it should be, there's certain notice and service requirements as well that have to be satisfied. Once the board of directors receives the requisition for the meeting, they have to respond within 10 days. They can either call and hold the meeting, they can not respond, and in that case, the meeting is deemed to be called, or they may advise that they will not call or hold the meeting because there's a deficiency in the requisition itself, and then it allows the requisitionist to then cure that defect and then perhaps render another requisition. Sometimes if the AGM is coming up, the parties may agree to add the issue or the matter to the agenda of the AGM to save cost and to have it more streamlined in that manner. So some of the things that we often see in requisition meetings are, if there's some disaccord or some issues that the unit owners may have with certain aspects, let's say rules, as I mentioned before, if there's some disagreement about that, they may move to have certain rules amended or repealed, or appointment or election or removal of auditors and directors are perhaps the more common ones that we may also see. So these are some of the things that may be the subject matter of a requisition meeting. Other meetings, so you see on the slide there that says information meetings. These are meetings that the Condominium Act also allows the directors to hold for purposes of information. So these can be town hall meetings for some, let's say there's a major project coming up and the directors want to involve and to have input from the unit owners. And for that reason, they may have an information meeting where all the unit owners are asked to come and discuss a particular matter. These are very common as well, and they're usually in the realm of, where you're looking to build consensus or looking to find out what is the majority of unit owners' opinion on a particular subject matter. And for that reason, they're very useful. And it also goes a long way towards fostering that confidence and trust relationship that you want, of course, to be there between the board and the unit owners. It also goes towards transparency and openness. Some of the things that you're looking at unit owner meetings and expectations that unit owners may have is clear communication. You want to ensure that you engage with the unit owners, not only at the meeting, but this is something that of course goes all year round in the information that goes out to the owners, and to ensure that it's a respectful meeting. Michelle, I'll ask you to jump in as well. I'm sure of course you do a lot of these meetings. Are there any tips that you may have for running an effective owners meeting?
Yeah, definitely. Sharing and being a part of several owners meetings over the years. I've been to some really great ones, and I've been to some that could certainly have gone a lot better. I think I may overlap on a couple points, so I apologize if I do, but I think setting a clear agenda is key. Setting a clear agenda so you have lays out the expectations for the meeting. And again, it outlines the clear talking points. Another key component, having a strong chair. The chair of the meeting has a very important role. They control what goes on throughout the meeting, especially if it's a contentious issue or you got a bit of a rowdy crowd. You want a good chair who's a good speaker, who's going to stay on the agenda and know how to control the room. A good tip for AGMs or any type of information meeting, have the board or as a manager put out a communication in advance of the meeting to ask owners what they would like to discuss at new business. Then the board and management can be better prepared to answer those questions in detail when they come up. Always bring extra copies of any packages or information circulars and extra pens if you're doing voting. And always bring in the professionals when needed. If you're passing a bylaw, bring in the lawyer to explain the bylaw, bring in the engineer to talk about the major project you're doing. So those are just a few tips from the management perspective.
Thanks, Michelle. Those are excellent tips. Like I know from experience that even not having enough copies or pens to go around can sometimes be a big issue. So thanks for pointing those out. The last thing I'm going to talk about with respect to meetings is just what are the timelines that are involved and required under the Condominium Act to ensure that calling the meeting properly. So the requirements under the act are that you have to send out 2 notices. The first notice is called a preliminary notice. It goes out at least 20 days before the actual notice of the meeting. So the preliminary notice, and these are all prescribed forms. These are forms that the provinces put out that have to be used. So, and they're supplementary documents that the board of the property manager may be putting together along with these forms, of course. But the first notice, the preliminary notice, goes out at least 20 days before the actual notice of meeting. So it's always a good idea to kind of figure out when you want to hold the meeting. So let's say now with things opening up again, maybe some corporations are thinking of having physical meetings, let's say in October, November, for example. So it's always a good idea to kind of backtrack from then and make sure that you're meeting the statutory timeline so you can send out the proper notices within time. So 20 days before the actual notice, and then the actual notice of meeting has to then go out 15 days, at least 15 days before the day of the meeting. And then again, like I said, there are forms that are prescribed that you have to follow and fill out and send out. So you have to ensure that those proper forms are sent. And there's also requirements, of course, for service and how these notices go out to unit owners. You may also want to, of course, ensure that you're sending out the proper and collecting the proper proxy forms, which are also prescribed mandatory forms. And that's it for me. And I'll continue to monitor the chat at my end, Q&A, and respond to any questions there. Over to you, Michelle.
Well, just to mention, there's one great question came in. Remind me to bring it up at the end, and we'll discuss through it. It goes to changes to common elements.
Okay, will do.
All right. Okay, so I'm going to cover some of the property management aspects of this presentation. So the first thing we're going to talk about is the options for property management. What do you as a board or your community have for various options for property management services? So there's 4 options to choose from: self-management, direct employee, company/contractor, or a hybrid. So the first one is self-management. Self-management refers typically to when a board of director carries out the management duties. If this director is paid for their management services on behalf of the corporation, they are required to obtain a license because all managers in the province of Ontario are now required to be licensed through the CMRAO. So if you are being paid as a director to do self-management for your condominium, you must obtain a license. If you're not being paid, if it is fully volunteer, then a license is not required. So this self-management typically works for smaller communities, or so that's what I see in my experience. I'm just going to highlight, when we go through each type of management, I'm just going to highlight a few pros and cons or benefits and disadvantages to each option. So self-management, there may be a sense of accomplishment for the director or directors working to manage the condominium because of the hands-on factor. They're working with contractors and supervising projects as opposed to handing it off to the property manager. Directors and owners will realize and appreciate that it's not the condo corp that should be doing things covering expenses, that they are the condominium corporation. You can provide more of a personal touch to your community as opposed to a corporate or company approach. It may involve a higher level of interest from all owners when they see a fellow owner who's doing a lot of the legwork to help the community. That makes it can just be a little bit more of a personal touch. And there's definitely cost savings involved when you're not paying a management company management fees. There's going to be a cost savings to your corporation. I mean, even if you're paying a director, it's usually a lot more cost effective than paying a management company for full management. Drawbacks would be, if they're not licensed, they have not taken the required courses. There may be a lack of knowledge without having a licensed individual or lack of expertise in certain areas. You may have to use consultants more often than if you had a manager in place, because the manager, again, has that training they may be able to jump in instead of going straight to a lawyer or an engineer for opinion or guidance. Direct unit owners may not feel comfortable discussing personal issues with directors. So, if I live in Unit 1 and Richard lives in Unit 2 and he's the president, I may not feel comfortable filing a complaint against someone when there's a neighborly community kind of going on. So those are some of the drawbacks to self-management. Continuity of records is also a big one. Your corporation has a responsibility to maintain records, so that's a large responsibility put on a unit owner who's self-managing. Again, enforcement can be difficult when you're living in the community and managing the affairs. People, could be knocking at your door, yelling at you because of an enforcement letter you sent. So that can create some issues as well. And it's very time consuming to manage a condominium. So it's a large role to take on for one of the owners. The next option is direct employee. So direct employee is a direct hire of the corporation. So they are a licensed manager, however, they do not work for a management firm. They are hired directly by the condominium corporation. The benefits are that you have control of the wages and salary of the individual versus the salary being set by the management firm. The condominium corporation sets the salary and builds that into their budget. And then you also have total control of the management function. Again, instead of having the management firm's policies and procedures and that the employee adheres to, the board of directors is the direct supervisor of that manager. Again, the drawbacks for a direct employee would be the cost of training. You have to invest the time in training the manager when this could be done by leadership at their management firm. Replacement for illness. So if your manager goes on vacation or is out sick for a while, the board of directors is going to be responsible for trying to find a replacement for that individual. Employer-employee responsibilities can be costly. There's no senior individual to turn to when things go wrong. Again, you are the supervisor of that employee. You'll likely also need to hire a separate employee or company for financial services. It's unlikely that the direct manager would be able to do management services and financial. And insurance may be available, but with a higher premium. And then the third option, company and contractor. This is probably the most common option that I would say. So essentially, corporation hires a professional management company, and then the company provides the manager or any other site staff for the corporation. So like if you have an on-site administrator, the condominium management firm could provide those as well. So the benefits to those would be time commitment as a volunteer is more reasonable for directors. So you're not involved as much in the day-to-day operations. The manager handles a lot more of those day-to-day activities, and the directors can essentially, do some emailing back and forth in between meetings, and really their role is to attend the meetings and direct the manager. Board can focus on governance rather than management. So again, manager handles day-to-day, board directs manager. There could be a potential cost savings as a result of volume purchasing. So for example, when you're hiring a direct employee, you're essentially paying that full salary. The cost savings, because they have a management company may have a larger portfolio of corporations and managers, you may see a little bit of reduction in your direct costs for management services. A lot of senior support staff. So if your manager is struggling, they have senior support staff and leadership to go to for assistance. If the manager's on vacation or goes off sick, there's usually the management company puts coverage in place determining based on the amount of time they're going to be away. The management package usually comes with administration and financial services as well, so you don't need to outsource to multiple people. You get the full package. Improve continuity. So again, for record keeping, your management firm's going to maintain all those records for you, so that takes the burden off the directors. And errors and omissions insurance is provided by the management company, as opposed to having, if you have a direct employee, you would have to try and obtain that yourself. Drawbacks to hiring a management firm: you're obligated to follow the property management firm overall process. So the management contract you sign will have a general layout of what the services are provided, and that's what you're going to get. Usually you're obligated to use the property management firm's banking institution. So most property management companies partner with one bank, and that's the banking institution that all of their clients use. You can't establish the same employer-employee relationships, as final decision on who your property manager is and staffing is not typically made by the board of directors. Although you may be able to meet with a manager before they're appointed to the site. Typically, the leadership at the management firm is the one who appoints the staff to your condominium. And then the last option is a hybrid. I would say the most common thing we see is kind of like a financial or consulting or a mix of both. So you may be a self-managed corporation, but you hire a management firm for financial and record keeping, and then maybe for consulting. So there's no, the manager doesn't attend monthly board meetings. They don't handle administration or correspondence with the unit owners, but you get monthly financial statements. And then if you wanted the manager to attend a meeting or come share your AGM, that could be built into the contract as a consulting service. So those are generally the 4 types of property management options that are available to condominium corporations.
Michelle, there's a question came in that goes to that last slide that you might be able to address. It's as a property manager, I understood that you are no longer allowed to self-manage your corporation. Can I get clarification on this? So I'm guessing if you're, like in your case, you work for Wilson Blanchard, if you lived in another condo, could you self-manage your condo?
Quite frankly, I'm not sure if it's specifically referenced, but I would say that's a conflict of interest. I can tell you, Wilson Blanchard, I would not be placed to manage my own condominium corporation where I live, and as a manager, I wouldn't want to do that anyway. So I don't know if that's specifically referenced, because you can have a license and be a property manager and manage your self-managed corporation. So I don't think that is a specific requirement or restriction, I should say.
Yeah, I'm not aware of any specific restriction. I can see this perhaps being a policy of the employer, the management service provider.
Correct.
Where they don't allow it because it could, if something happens, something goes wrong, they could inadvertently be drawn in because the person that's self-managing is their employee covered under their insurance. So that it could get a bit messy.
Yeah, and like I said,
I don't know.
From an internal standpoint, I can tell you, I mean, I know of, we have employees that live at Wilson Blanchard properties, not necessarily all managers, but we would never assign an employee, whether it's accounting or a manager, to a property which they live at. And again, like I said, as an employee of a management firm, you usually want to just go home and enjoy your property and leave that to your colleagues or to another management company. So I can say in our firm, it's a policy.
Bilal, do you have any input on this?
No, that's not something I've come across, to be honest. The insurance matter there.
I'm sorry, I can't hear you.
Can you hear me now? Sorry, just having some issue with my mic there. No, that's not something I've dealt with before, Richard.
Okay. So it's something that should probably be looked into.
Yeah.
Sorry, Michelle.
That's okay. Good question. Okay, so at this point, I'm just going to essentially talk about how board and management works together, what the roles are, and how you work cohesively in managing your corporation. So ultimately, the board sets the vision for the corporation. They set the vision for what they want their community to be and how they want it to be run, and then the manager implements that vision. So the board should know the basic premise of a corporation. So attending educational seminars like this is great for board members. And they should know what they want from their community. So are you a high-end luxury waterfront condominium, or you are a family-friendly community townhouse site? So you have to understand the vision of your corporation, and that will really help with implementing management and guiding management on the direction that the corporation is taking. So best practices for governance. Governing your condominium corporation, whether self-managed, direct hire, or by contract, should be a team effort between the site manager and the board. Unfortunately, from time to time, we do see that it seems to be a divide between the two, and it really needs to be a team effort for it to work efficiently. The manager is there to guide the board and act on behalf of them, and working as a team is truly the most beneficial way to get things done. The challenge can sometimes be is to identify what member of the team should be taking charge on an issue. So how does the board determine when they should get involved and when they should let the manager handle it? So I'm going to go through some tips on how to tackle that. First, you have to determine if the concern is really a board issue or something that's better handled by the manager. Board handles issues that affect the whole condominium corporation. The manager, director, handles issues that affect the individuals. The board dictates what the condominium corporation will do. In other words, the policies, and the managers implement those policies. The board handles matters that are dictated by bylaws or as requested by the manager. Unfortunately, many situations are not clear when it comes to responsibilities, and it's no surprise that conflict exists in the manager and board relationship. It's important to understand that directors do not take action as individuals. They must act as a team. Acting as a team, the board sets policies and goals for the manager to implement and achieve. So I think there was a question that came up earlier about this. So what this means is a manager needs to be taking direction from all 3 or 5 or 7 board members. There shouldn't be one board member that's giving direction to the manager. Everybody needs to be working cohesively. Again, I think I don't know how often we can say this, good communication is key. The more you communicate, whether it's as a board and manager or the board and owners or the manager and owners, communication is so essential. So that when responsibilities get confused, the board of directors and manager can resolve the problems. So again, board sets the clear vision for the property's future, and then the manager helps achieve that envisioned future. So I'm going to just quickly go through some examples of how to divide certain duties. So planning. So your property manager would create a plan, like an annual plan, that describes the anticipated operation of the condominium. The board would then receive that plan, review it, and approve it. And then the manager implements the plan and puts it into play on an annual basis. Board support. So the manager assists the board in setting up new bylaws, rules, policies, including evaluating current processes and making recommendations for change. Once the manager presents that to the board adopts the bylaws, rules, and policies. Operations. The manager should be administering day-to-day implementation of board-approved operating policies, and then the board's role in that aspect is to approve and advise the manager of what policies they want in place. External relations. So the manager obtains quotes, recommends trades and service providers. So an owner calls you up, my roof is leaking, the manager goes and contacts the contractor and gets a quote for the repair. The manager then presents that quote or 3 quotes to the board at a board meeting, and then the board approves the specifications and sets the level of service and approves contracts. Communication. The manager should be the main point of contact for communication on day-to-day issues, notices to owners and residents and all other stakeholders in the condominium. Keep owners and directors advised of significant operational problems or operational items. And then the board is responsible to set the communication plan. So sometimes as a manager, you know what your board expects of you. So when there's certain notices to go out as a manager, when I know my board and my community well, I know, this notice can just be posted on the bulletin board, and this notice needs to go to every unit, or I know the board likes this style of communication to go out, or so, as you work with the community, you and the board kind of learn how, again, how to implement the vision of what the board has. Direction and leadership. The manager should provide administrative support to on-site staff who have the responsibility for day-to-day operation of the condominium property. So that could be a superintendent. The manager works closely with the superintendent. And then the board directs and leads the condominium corporation through the manager. Enforcement is a good one. So The manager is the point of contact for enforcing bylaws, rules, and policies. So if there's a rule violation, I go do a site inspection, I notice a rule violation, the manager would then send a letter to the owner advising of the rule violation. The board's role in that is they create the initial bylaws and rules for the corporation. So those are just some examples of how the board and management work together in creating a vision and implementing it. Was there any questions on that section that I need to touch on? Nope, okay. All right, so now we're gonna go over planning, financial, and other responsibilities. So the first thing we're gonna talk about is an annual plan. An annual plan is a great tool for a condominium corporation. It's a great tool for the board and the manager. All corporations run on an annual calendar. It may not be the regular calendar year. It's going to be based on your fiscal year. And the fiscal year and the year end is usually related to the original registration date of your condominium corporation. Things that run annually, your annual budget, your annual report to the owner, yearly contract renewals. Best practice is for the board of directors and management to develop an annual plan that sets out expectations contained in the budget and pinpoints when the work will be done. So things that you would consider to put in your annual plan would be the plan will set the month for the AGM. So we all know the AGM needs to be held within 6 months of the corporation's year end. The plan could include the dates for the board meetings. So if you schedule all your board meetings for the year in advance, you can put those in your annual plan. Renewal dates for contracts, renewal for the insurance policy, dates for routine maintenance and routine communication notices. So perhaps you send out a spring and fall newsletter every year. Put that in your annual plan. Do you do stat cleaning once a year, or when do you do the garage cleaning, the window cleaning, all that stuff. So you essentially just lay out a master plan of what takes place in a year, all the important things that take place in the year. It's a great guide and resource tool for both the board and management to work off of. Budgets, money, and banking. So there's the annual, so there's the operating and the reserve budget. We're going to talk about board authority versus increased transparency. CEA, I say CEF, common element fees split into operating and reserve accounts. And we're going to talk about check signing. So it's important to understand the meaning of community living in a condominium and the differences between condominium living and living in a house before discussing budgets, costs, collections, money, financial statements, etc. Living in a house, we all know it allows you the freedom that is not possible living in a community environment. For example, if you needed to fix your fence or replace the roof or clean the windows, this can be done on your schedule based on your financial availability. If the money's not available to fix the roof, you can defer it for another year. It's just the roof over your head, not the roof over 50 other owners' heads. Moreover, the garden maintenance, snow removal can be done at a convenient time, regardless of neighbors' opinions. You could also plant whatever you want in your garden, regardless of what your neighbors feel. In condominium, you don't have these options. It's a community, and we all have to live cohesively. Owners expect the building to be clean, orderly, a good condition. When owners consider resale, curb appeal is very important. So you want landscaping and snow removal is a very important aspect. We have to think of the community when we need a fence or a roof replaced, because that's also important to the value of your unit, is ensuring everything's good in good maintenance and repair standard. Owners need to realize that their personal financial circumstances and expectations do not and cannot determine the condominium's costs. It's collective circumstances and expectations. Owners have to understand that owners have to understand that not all costs benefit all owners equally. So one of I always like to kind of reference for this is, when the roof is failing, only the owners on the top floor are typically affected. They're the ones that live right below the leak or the roof. They're the ones that are going to get affected by roof leaks first. So the owners on the first floor may not see the need to, pay for the roof replacement, while the owners on the top floor are being directly affected. So that's kind of how my interest as an owner and someone else's interest of an owner can vary, but we all have to contribute collectively to an issue. So let's talk about budgets, common element fees, and collections. So the budget for the condominium is set annually. It does not require a vote of the owners. So I think that's something good to clarify. That comes up a lot is I get an email from an owner and says, there's no meeting to approve the budget. The board approves the budget. So that is something that they have the authority to do. The budget identifies all the services and costs of running the condominium corporation. Once the budget is approved, the board needs to send a communication to the owners. Should be a thorough budget package. There should be a cover letter that outlines the reasons for any increase or challenge or changes to the budget, any challenges that the board faced in the budget process. The letter should also advise the new fee amount, when the budget begins, what the payment options are, and where to send their payment to. Typically, most fees are paid either by pre-authorized payment or by post-dated check. Common element fees are calculated based on the percentage set out in Schedule D of the declaration. So this is set out when the declaration is created and the condominium is registered. It does not change from year to year unless, of course, your declaration is amended at some point, but I think very, very rare. When you send a budget out to an owner, it should just be essentially just break down the expenses. It should have the prior year amount and the current year amount. Sometimes treasurers of the board like to include a treasurer's report to provide a little bit more detailed explanation, which I think is great. Sometimes if, let's say there's a large increase to the budget for some reason, or for example, if you're levying a special assessment this year with your budget, it can be very beneficial to hold an information session after the budget has been distributed to owners. It gives the owners a chance to voice their feedback and opinion on the matter, and it gives the board an opportunity to have a further detailed discussion about the increase. Bilal and Richard, I don't know if you want to jump in and just touch on the board's authority to levy a special assessment.
The authority comes from two places. One is that same authority as they have for doing the budget, which is Section 17, the overall right to manage the property. And that issue actually went to court back in I think it was 1998. With the special assessment, the specific authority is strictly found in the bylaws, the general operating bylaw. And the wording, again, generally is if something comes up which is unexpected, the board's got the authority to levy the assessment on giving minimum 10 days notice and explaining why. It's not a voting item. The assessments, I think, are, at least in my practice, much fewer than they were before mandatory reserve fund studies came into effect in 2001. That case I was referring to that went to court had to do with a board trying to fund its operating through special assessments, which was just absurd. But now it's now it's more to deal with the unexpected than the unplanned. And I'll let you go back to that now, to your part now.
Okay, great, thank you. So when it comes to collection of fees, the corporation's bylaws will set out how owners are required to pay their common element fees on a monthly basis. Again, the industry standard is that owners pay either by post-dated checks or pre-authorized payment. As industry options change, online banking options for payment may become more common. So electronic funds transfer, or a lot of owners ask if they can pay by credit card. So those may become more available, as technology continues to advance. Cash is not recommended to be accepted for common element fee collector payment or any other payment owed by an owner. So we would recommend always either check or pre-authorized payment. Another thing that you come across from time to time is, and actually I will say with COVID and the closure, I don't want to get into a debate, but this has come up a lot recently, is with the closure of amenities. We get the, well, if I can't use the pool, then I'm not, I'm only paying a quarter of my common element fees, or I'm not paying any of my common element fees because you haven't fixed whatever component of the building. The owner has no right to do that. There's no grounds for refusal of common element fee payment. They are required to contribute and cannot be exempt, even if they have waived or abandoned their rights to use the common elements. Again, or if the owner is making a claim against the corporation, and or if the declaration bylaws rules restrict the owner from using the common elements or part of them. So regardless of whether they waive their rights or their rights have been removed or they're making a claim, still required to pay full common element fees each month. Again, common element fees are typically due on the first of the month. The reason being, it's a good tool for lien deadlines, counting lien, which I'll get into. So if an owner defaults, the corporation has the right to require a lien against the owner for the unpaid amount, together with all interest owing and reasonable legal expenses associated with administrating the lien. Should the owner fail to pay, the corporation has 90 days to register the lien to give the corporation priority over the mortgage. So if an owner falls into arrears, they have 90 days to pay that outstanding amount. If they do not pay, then they about 15 days prior to the 90-day period, they would receive a notice of lien advising that if they don't pay the outstanding amount by the 90th day, the lien will then officially be registered on their unit. And Richard, I saw yourself on mute. Do you have a comment on this?
Just something that tends to get overlooked. In 2001, when they brought in the mandatory notice of lien, it's like a mandatory pre-lien, pre-notice to the owner. It used to say, the act used to say that you would send that to the name and the address that shows up in the condo's register. About 2 years ago or 3 years ago, I forget, the act changed, and it now says you've got to send it to the name and address that shows up at the land registry office. So that in my view, what was supposed to be a very informal, although prescribed form, but very inexpensive pre-notice has now gone the other way, and it now requires that you sub-search title before you send it out to comply with the act. And I want to stress that because it's still overlooked a lot in practice.
Thanks, it's a good point. While the Act protects the condominium for non-payment of owners, the collection process, again, will be set out in the corporation's bylaws. The board of directors should review the process and set a clear policy. So as we were talking about earlier in the presentation, a lien policy is quite common. So the board should ensure that they have a policy with collection of lien. A lot of the times, if you have full management services, the management company is monitoring this for you through their accounting department. They're typically, again, they're just going to ensure that they're collecting the fees and securing the amount for the corporation. But if you're self-managed or you have a direct employee or financial and consulting, you want to ensure you have a lien policy in place for how that process is going to go. Because if you miss that 90th day, you could be in jeopardy of not being able to collect fully. So it's very important to have a policy in place for lien collection or arrears collection. Another key thing is that you need to ensure that you're depositing reserve amounts promptly every month. So we're going to get to this, but the corporation's required to have an operating bank account and a reserve bank account. Typically, again, I'm basing on my personal experience, when the fees come in on the first of the month, they all go into the operating bank account. And then either the management firm, their software has the capability to do an automatic transfer into the reserve, or sometimes I think you might have to cut a check to pay the reserve. So I would either recommend the automatic transfer or post-dated checks and ensure it's done promptly after the collection of fees each month. So again, the Act sets out what corporations can do with the money collected. Sections 84 and 15 of the Act cover this very important aspect. Section 84 teaches us that the common surplus, so the common, essentially the surplus at the end of the year, shall be applied against future expenses or paid into the reserve fund, except on termination, and it shall not be distributed to owners. So what this means is that at the end of the year, if your corporation ends the year with a surplus in fees, or surplus in fees, Either that surplus is carried forward and applied to future expenses in the future years, or the board could do a one-time transfer of the surplus into the reserve fund. But if you end the year with an extra $10,000, we don't all get a refund divvied up and given back to us. So that's what Section 84 says. Section 15 guides the corporation on handling of the funds. So again, like I mentioned, the corporation is required to maintain one or more bank accounts for general operation and one or more bank accounts for the reserve fund. So typically most corporations have two bank accounts, one for the operating, one for the reserve. Again, if you're with a management firm, typically you're going to be banking with a financial institution that they're partnered with, and they will set up the accounts for you on behalf of the condominium corporation. Occasionally, you may have a third bank account if the corporation has a loan. I'm not going to get into detail about that, but depending on who your loan is with, you may also be dealing with a third bank account in a separate banking company. So as I mentioned, common element fees should be collected on the first of the month, deposited into the operating account, and then transferred promptly into the reserve fund. Yeah, okay, covered that already. Yep. Okay, so last but not least is check signing. So pay your fees. The management company typically cuts checks. Again, this may be different if you're self-managed or in a direct employee. But the board of directors will be required to sign all the banking authorization documents to set up the bank accounts, and then designate signing officers. To ensure timely payments of some expenses, for example, your utilities, most corporations will set up pre-authorized payment for these expenses. So much like individual home ownership, typically your hydro, water, gas, utility expenses come out pre-authorized each month. So you get a bill, it tells you the withdrawal date, and that'll just come out, and that ensures everything's paid on a timely basis, and you're not getting in trouble with utility companies for not paying your bills. And then for the remainder of your expenses, there's generally three options for check signing. So the first option is 2 directors sign each check. The second option is 2 authorized officers of the management company sign each check. And then the third option is a hybrid, 1 director and 1 authorized signing officer from the management company sign the check. In most cases, all directors, so all board of directors are given signing authority, but there's typically 1 director who's the main person who's appointed to sign the checks, most often the treasurer. But it's good to have multiple people signed up for signing authority in the event, your treasurer goes away to Florida for the winter. He's not there in person to sign checks, so the president can sign checks in his absence or their absence. It's recommended option 1, so 2 directors signing the checks, is probably used the least, and it is the most risky option for check signing. When 2 directors have access to the funds, there's more likely chance of collusion, which could result in the loss of funds. The corporation's insurance provider will specifically ask who signs the checks and how many people sign the checks. If the checks are not co-signed by a third party, a bond to cover theft or fraud, or theft of funds will not be granted. There will be more on insurance in CCI's advanced course, so that we can touch on this a little bit more in the upcoming insurance seminar. Option 2 is the most often used by townhouse communities or very small corporations or common element corporations that have very few checks signed each month. So again, option 2, just as a reminder, was 2 authorized signing officers from the management company are going to sign your checks. This is a good option for communities where it's a challenge to deliver the checks to the board member for signature. Sometimes the board members just aren't interested in signing the checks and they delegate the authority to the management company. Or there's, if it's a townhouse community, there's no office or security desk to leave the checks when you drop them off. So it's a good option for those types of corporations. And again, it even applies to larger corporations where they have the trust and confidence in the management firm to sign the checks on their behalf. Option 3, definitely the most common, is 1 management, 1 director. This reflects a partnership of responsibility, not only for producing complete and correct payments, but timely payments as well. However, the board should clearly understand who are the signing officers for the management company, to ensure they are in a senior position, and so the board can confirm signatures. So most management firms only have a set list of authorized signing officers. The board should make sure that they know who those people are, because they're the ones signing the checks on behalf of their corporation. For proper financial risk management, the site manager should never be a signing authority on corporation checks as they issue payment approvals and purchase orders. So the signing authority, if often senior property managers could be signing authorities at management firms. The property manager should not be signing checks for their own corporation. There's just too much risk there, because the property manager issues the purchase order, they approve the invoice, and if they're signing the check, there's not enough internal controls for the risk of fraud. Due to the size of major management companies, the number of checks processed each month for signature is high. The use of electronic signatures will become more common for payments within the signing authority of a management company. In this case, the board needs to be comfortable with the security in place to protect against fraud and errors. So I already know that some management firms are moving towards like electronic payment systems. So their invoices are all online, approvals done online, and it's, instead of checks, it's electronic fund transfer, which I can tell you just the number of checks that we cut in our office on a monthly basis is probably in the thousands. So moving to those types of options are definitely beneficial. And I think they're beneficial for the board too, for those board members that like to see the invoices before the checks are cut. They want to approve them, they want signing authority. It's a much quicker and efficient way. So I see more and more management companies adopting that type of software. All right, monthly financial statements. So financial statements are usually prepared monthly by a management company. Industry standard is for the statements to be prepared no later than the 20th day of the following month. Most management companies are sending their financial statements electronically, or they're available to the board on a cloud-based server for access. Some board members still like to receive a hard copy of it, maybe with their monthly management report. Typically, the statements include a balance sheet, income statement, arrears schedule, bank reconciliation. Some include, details such as general ledger, various ledgers for receivables and payables, a check detail, but at a minimum, balance sheet, income statement, arrears, bank reconciliations for both operating and reserve account. It's good to try for corporations to try and schedule their board meetings a little bit later in the month. That way you can have accurate and timely financial statements to review. So depending on what the timeline is from your management firm on when they deliver those statements, try and plan your director's meeting just after that so that you can ensure you have relevant statements to review at the meeting. Once new statements are received, the previous month is redundant. So if the board meets every second month, you only need to be approving the most recent statement. The statement is not approved by the board as it is not an audited statement, and the numbers may change, especially if the item was overlooked and did not get posted in the correct month and it is corrected later. So for example, if the board's reviewing a statement and they notice an expense that went into the wrong account and they want it reallocated, management firm typically does not redo that month's statement. You'll see the correction made in the next month's statement. So that's just kind of what that touches on. I want to just touch on review at board meetings. So when you receive a financial statement, it's a key things to look at. You want to look at your bank account, balances of your bank accounts, your operating reserve surplus. You want to ensure that you're not running a deficit. And if you are, where is that coming from? So the manager preparing and providing a variance report to the board is very helpful when reviewing the statements on a monthly basis. You also want to look at your arrears statement. Do you have somebody 30 days arrears, 60 days arrears? Keep that on your radar because again, if you're approaching that 90-day timeline, you want to make sure that you don't miss the lien on the outstanding arrears. So those are just kind of some key things to look at when you're reviewing the financial statements on a monthly basis. So lastly, I just want to do a brief overview of reserve funds. So the purpose of the reserve fund is the major repair and replacement of common elements and assets of the corporation. The reserve fund study is essentially the funding plan and the kind of guidebook as to how you're going to spend your reserve fund and what projects you're going to complete. And it's prepared by typically by an engineer. And then there's the budget of the reserve fund expenses. So a reserve fund is essentially a trust fund or a savings account established by the Condominium Corporation for the purpose of major repair and replacement of the common elements and assets. The Act states that the minimum amount contributed in the first year after registration cannot be less than 10% of the operating budget. The contribution amount that the Board of Directors determines after the first year has to be based upon the reserve fund study. These levels are generally much higher than 10% of the operating budget. So yeah, after the first year of the budget of the corporation, you're going to see usually higher contributions to the reserve fund study. And then once you have an established corporation, after quite a few years, you will see the contributions drop below 10%. That's just, again, my personal experience from all the reserve fund studies I've seen. But you will go through cycles where they do creep up again. So you may have, 5 years of a 3% increase and then it goes up again, but it's all determined by the engineers and the study they put together. Contributions made by an owner to the reserve fund become property of the condominium. Owners do not receive a rebate of reserve fund contributions from the condominium in the event that they sell their unit. There's no credit for these contributions in the closing adjustments. So theoretically, the purchase price of the unit should reflect the investment that the owner has made to the reserve fund. Another key thing I just want to note, because this comes up a lot as well, is once money is put into the reserve fund, it cannot be transferred out. So I get that, I get a lot of boards that are short on cash in the operating and they're like, can we just borrow it from the reserve fund? No, once it's put in the reserve fund, it stays in the reserve fund and it's only used for reserve fund expenses. This comes up when boards are considering transferring a surplus. When you're thinking of transferring a surplus from your operating fund into the reserve, just remember that once you move that money in there, you can't move it back again if you determine you need it. So that's just something to keep in mind. The Act makes it mandatory for condominiums to obtain an independent reserve fund study from a qualified engineering firm or other permitted provider. The study analyzes the state of repair of the different components that make up the common elements, the remaining lifespan and project, and in today's dollars, the amount of money the corporation will need to repair or replace the components over the next 30 years. Again, I think another key component that I see come up a lot with boards, a reserve fund study will be done, and then let's say before the next reserve fund study is completed, reserve fund studies are required to be completed every 3 years. There's a roofing issue. And I hear so often, well, they just did the reserve fund study 6 months ago. Why wasn't this caught? Or why didn't they do a thorough review of this situation? It's important to remember that a reserve fund study is not an in-depth look or it's not an in-depth assessment of each component of the common elements. It is more of a general overview of each component. So what I always tell my boards is that if there's a specific issue, certainly let the engineer know, but there may be an additional cost to do an in-depth assessment at the same time or at a different time than when the reserve fund study is conducted. So just remember that it's not an in-depth assessment. They're not out there doing water testing on the roof when determining the reserve fund study contributions. So I see that come up a lot, so I just wanted to make that point. But the reserve fund study is required to be updated every 3 years, which is mandated by the Condominium Act. Each study every 3 years will switch between a study with a site inspection and without a site inspection. So you should be getting an inspection of your property every 6 years by your reserve fund study provider. Now, if the board wants to pay for the cost of a on-site inspection every 3 years, by all means, they can do so, but is not required under the Act. Any questions?
Michelle, one just came in. If you've paid something out of operating account, which should have been paid out of reserve, can you transfer funds back to operating from reserve?
Yes. So I've seen this done with our own financial accounting statements. If you paid for something out of the operating and you've determined that it could be a reserve expense, you can move it. And I've seen the auditors do that as well.
I just add, you might want to bounce it off the auditor.
Yes.
That was a good idea.
Doing it.
Yeah.
Go
ahead.
Sorry, go ahead.
No, go ahead.
To add something to your comment about the reserve fund study and the in-depth studies, I always like to think of the reserve fund study as a savings tool, whereas the in-depth studies are more spending tools. And one's not, you shouldn't confuse the two.
Yeah, and I think just with you saying savings tool, I think another key component to think about with the reserve fund study, I always like to say, like, it's not a Bible, it's a guidebook. So when you're reviewing the reserve fund study on an annual basis, if it says you need to replace all your windows next year, and you very well know that the windows are in good shape, but your roof is falling apart, don't fix the windows because the reserve fund study says you have to. It's a guide, it's not mandated. So just keep that in mind, that you don't have to follow it line by line. That's why it's updated every 3 years. If you go off guide a little bit, you'll catch it in the 3-year update, and the engineer will adjust that. So just keep that in mind as well, that it is a tool. It's not something that you have to follow line by line.
I've kicked you off. We're going to, I've just got 3 small topics to do, and then we'll finish up, take general questions. All 3 of these topics are dealt with in much more detail in the advanced course. Plus, for insurance, we've got the condo talk happening, which should just have some fabulous discussion on the topic. So we'll start off with insurance. So this is the property side of insurance. And what the Act says is, it's under Section 99 of the Act, the corporation has to take out insurance on behalf of the condo, all the unit owners, and all the mortgagees. All 3 of those parties, if you look at your certificate of insurance, all 3 of those parties are named on it. And I really want to stress that, because as we think about ways to manage insurance risk, I'm going to touch on it a little bit, we start forgetting about perhaps the mortgagee, because they're fairly silent in voicing their concerns. I think they're almost always silent, but they can't be forgotten about because they are a named insured. So the policy gets taken out in the name of the condo, the owners, and the mortgagees. What does it cover? It covers everything, the common elements and the units. Now, the limit on the units is it doesn't include betterments or improvements to the unit. And how do we know what is a betterment or improvement? It's in reference, we look at the standard unit definition. That could be in a bylaw, or it could be a schedule. If you're a condo that was registered before May 5th, 2001, you might not have either. And what we try and do, and there's no perfect answer here, we try and look at the state of the unit as it was originally constructed. And I just remember homes built in the early 70s that had shag carpeting and purple toilets. And I don't quite know why anyone would want to go back to that standard. So if you haven't got a standard unit definition, get one. It's really important. Unit owner insurance. It's not mandatory. The older condos say it's a good idea to get. The newer condos use language which suggests it is mandatory. I'm not sure if it is yet. It just, to me, it puts the onus on the owner. My big thing is I don't know how a condo would manage that or enforce it. But the reason that you still want to encourage owners to get insurance is because it's in their interest. It's not expensive, because the condos coverage does the heavy lifting, and the owner's policy will cover things such as betterments and improvements, all the personal effects. If the owner's got to live outside of the unit while repairs are carrying on, that's on the owner's policy. If you're ever held responsible for the corporation's deductible, that's on the owner's, you can get the coverage on the owner's policy. And finally, there's something called assessment coverage, which relates to a circumstance where the condo's coverage was not enough. And if the condo's coverage is not enough, where's the condo go for money? Back to the owners, and you can get coverage over that. So always ensure and really encourage unit owners to get their policy or to get their own insurance. Why do we want to do all this? We want to really think about how to manage risk in a condo. Insurance premiums and deductibles have been skyrocketing of late. So we really want to get a handle on how to manage that risk. And barring some form of mind control to control what owners do and how things behave, there's really two options here. One is recovery of the deductible, and the wording, it's got to, well, the act says you can recover deductible where there's some act or omission of the owner which has caused damage to the unit. It leaves out the damage to the common elements and other units. It also leaves out, or it leaves open the argument of what is an act or omission. And back when deductibles were $5,000 or $10,000, or at least that was the norm, I'd always think, why would anyone want to get into a fight over $5,000 to $10,000? At least why would the condo? It doesn't make sense. It would be eaten up in legal costs in no time. So what you want to do that, therefore, it's still legal to put a bylaw in place to extend the circumstances. And for me, when I think about extending the circumstances, I want to bring in other units and the common elements. I also want to get rid of the act or omission. I look at a source unit, basically a strict liability offense, and leave it that way and get rid of that future fight. There's an expected change coming to the act. It's in Bill 106, which will require the source unit approach to be put in the declaration. It's going to be difficult to do 90% approval. If you do that, look at your other indemnities at the same time, because again, the indemnity provisions in a condominium is how you again manage risk, and a lot of them, besides just the insurance deductible, a lot of the other ones are really lacking generally. The other way to manage risk is the standard unit definition. And I want to talk on this because I'm hearing more and more discussion about these bare bones definitions. Let's just put the unit back to the unit boundaries, and it doesn't work. At least in most cases, there's always exceptions. But when we do that, we're making a unit which is not usable, and where the selling price is really compromised. And when that's the case, when we look at who's relying on this insurance, the condo, the unit owner, and the mortgagee, that mortgagee, their interests are not being supported. We haven't got a fight yet on that, but I think that will come at some point. To me, the standard unit should put the unit back to a usable and a sellable condition. Next topic, STAS certificates. Again, this could be an entire talk on STAS certificates. When you go to buy a condo unit, there's the title searches, the on-title searches, see who owns it, who owes money, who the mortgagee is, etc. And there are the off-title searches. And the STAS certificate is an off-title search, but it's probably the most important due diligence anyone can do when buying a condo. And the reason being, it describes what you're buying into. You're buying into a going concern. It's like buying shares in the company. You want to know what's going on, what it's about. Is there a lawsuit coming up? Is the condo short of cash? You want to know all about this, and that's what the STAS certificate gives you. Now, the cost of STAS certificates is it's $100 including HST, which if any of you remember your history, the $100 plus GST was established in 2001, and it hasn't moved. So when GST became HST, the amount the condo or whoever is getting to keep that money, it hasn't gone up in almost 20 years, and in fact has gone down because it's being taxed more. I think it's too low. given the importance of that document. When the condo receives a request, the request should be in writing and you should get the money before acting. You then have 10 days to complete it and to get it out. As far as delegating responsibility, if most management contracts have a provision where the manager will take over doing the staff certificate, the manager can keep the $100. And if that's the case, God bless them. They're taking on more risk than what the money's worth. And by contrast, you're getting, as the condo's getting rid of that risk at a very low price, which is super. But the board, well, the management contract should state it. The board should pass a resolution confirming that. The board should also, though, stay in touch with what's going on, should review the staff certificate from time to time. Don't ignore it. If something big happens in your condo and maybe an unexpected, that roof that Michelle was talking about that needs to be done right away, ask the question, does something need to change in the staff certificate? How is it being changed? If you end up being sued, ask the question, does that need to be reflected in the staff certificate? If it does, get it done. Because the staff certificate, notwithstanding that management might be filling it out, it binds the condo as at the date it's signed. So what else is with the staff certificate? It's basically 4 pages. The certificate itself is 4 pages. It goes into, describes the unit, and the legal description of the unit, describes the common expense aspect of that particular unit, whether a lien is on it, etc. Lawsuits, conflict, reserve fund study implications, etc. But it also has a lot of attachments attached that come with it, and those attachments include that declaration, the bylaws, the rules, the budget, the audit. Sometimes other contracts get lumped in, the insurance certificate. And again, when you're buying a condo, all of this plays in to that entity that you're buying into, and all of it should be reviewed and the implications understood. Condo's only valid, or it's valid as at the date it's signed. So if the day after you sign it, Michelle comes to you and says, "Uh-oh, we got to do the roof, we haven't got the money," what do you do? Well, the answer is nothing. All right, you've done your obligation yesterday. All right, in my view, if a purchaser's lawyer is doing their due diligence correctly, there should be 2 status certificates on every deal. One at the preliminary due diligence stage before requisitions are issued, and another one just before closing, because you want to make sure nothing's changed. But there's no obligation to update. I know a lot of managers get verbal requests, has anything changed? And a lot of managers spend a lot of time answering those questions. It's meaningless because it doesn't bind anybody or anything. Now, what happens if the staff certificate is not prepared within the deadline, or if, or a lot of them are just messed up, they don't follow the prescribed form? Well, if it's not prepared, there are deeming provisions in the Act where it's deemed not to have certain information. So there's no common expense arrears for the unit. There's no special assessment. The budget hasn't changed, etc. But again, just as this is an off-title search, to me, if the staff certificate is not being issued, or if it's being issued and the form is completely other than what's required, what's prescribed, it's telling me that this condo has got an underlying management problem, or there's an underlying problem with that condominium. And I tend to read my client the Riot Act when I see staff certificates like that. Last thing I want to talk about is other laws. We always like to think of condos as being governed by the Condominium Act, and that's it. It's a lovely little act, and everybody's jealous at lawyers that do this because it is a lovely little act. But the reality is, it's hard to think of any law out there that doesn't touch condos in some way. All right, the big one that we all hear about lately is the Human Rights Code that trumps the act and the declaration. Yeah, we've got a few years back, it was PAPETA dealing with how you deal with that confidential information that condos tend to collect. There's a lot of debate whether PROPETA even applies to condos because it's, it tends to, the correct definition is information collected in commercial activities, and condos tend not to be commercial. Property management companies are. Very clearly they're covered or they're caught by PROPETA, but condos not so much. Recent case, I believe it was a CAT case that confirmed that condo is not. That said, you still need to you should still have a policy on how you're going to deal with information collected and documents. Occupiers Liability Act, well, the condo is the occupier of the common element for liability purposes. So that's actually brought in right in the Condominium Act. Occupational health and safety, workplace violence and harassment. More and more cases we're seeing where the attitude or the somewhat harassing approach brought by some is being taken, is being, it's not being accepted. Very often it could be an owner going after property management. Nobody signs up, either professionally or on a volunteer base, to be harassed in the condominium. It happens too often. The courts are coming down against it, which is the way it should be. And it's etc. There's so many other ones: the Criminal Code, the Environmental Protection Act, the Mortgages Act. Mortgages Act are the lien files, etc. It goes on. So don't expect the Condo Act is the only place to look. We're going to end it there. I want to again remind everyone of upcoming events: the upcoming condo talks on insurance, upcoming condo talk on board authority, and the enhanced director's course. We've made references to that throughout tonight. Again, it's just an incredible, at least I see it as an incredible course. I'm perhaps biased. Again, TCI is, we want your feedback. We do rely on sponsors. We also rely on volunteers. All the speakers tonight are volunteer. We all volunteer our time to CCI, believing in, it makes our client, our work easier if our clients know a bit more about what their obligations and limits are. Now there's some questions, I believe. I'm going to stop that last slide, get out of sharing. And I believe there was an earlier question which I put off.
Yes, changes to the common elements.
Right. Do you have that one handy? Oh, here it is. So it's from Lorraine. And Lorraine's been very patient because she asked this over an hour ago. I'm in a townhouse and a single home condo group. Single homes have walkways to the front doors leading from the driveway. In the past, some homeowners chose to repave their walkways, which then became the responsibility of the homeowner. We're now undergoing repaving of the common roads, driveways, and walkways, which are our responsibility. We're giving homeowners who are responsible for their walkways this opportunity to have them redone at their expense. This is my question: if they choose to get the walkways redone with the rest of the cul-de-sac, does the responsibility revert to the condo once again, and as is now in compliance with the rest of the area? Bilal, do you want to take that one?
Sure, Richard. Are you able to hear me? I just want to confirm first.
Yeah, we can hear you.
Great. So there's another question as well which touched upon changes to common elements, and you did allude to in the answers that there are two provisions in the Condominium Act which deal with changes to common elements. So if an owner wants to make a change, and I'm just giving some preliminary information here, if the owner wants to make a change, you're looking at Section 98, and there's a whole process that has to be done, and there has to be an agreement for an owner to make changes to common elements. On the other hand, if the corporation, the condo is looking to make changes to the common elements, then you're looking at Section 99, and there are procedures in that provision and different thresholds that you're looking at to determine what is the right process to take to for the corporation to change common elements. In this particular case, the fact pattern, I would definitely
recommend having a closer look at the existing Section 98 agreements for those driveways to determine what the obligations are, and if they are in fact now taken up by the corporation as part of this remodeling or reconstruction process, then that agreement, which was probably registered on title to those units, may illuminate on this issue. So that would be a good starting point just to get an idea as to how to take this forward. But if the corporation then absorbs it, it would be based on that preliminary assessment. What are your thoughts, Richard?
My thoughts, to me, it depends on what the condo did way back. Like when it originally gave the okay to pave the walkways, was the Section 98 agreement put in place? And if it was, then that agreement should answer this question. If it wasn't, and if the condo continues down this road, we have a really muddy situation because the walkway is probably common element. The condo is paving it, and an owner could take the position that it is back to condo. I like things clear. I really don't care which way it goes, but that agreement's critical.
Definitely.
Yeah, and as from a management perspective, especially with the older townhouse condominiums, we see all the time all these improvements made, but never Section 98 in place. And I think it's important for boards to know how important those agreements are, and really how it protects the condominium moving forward. Because the board that's there and the owners that are there at that time may not be there in 20 years. And then, like you said, Richard, it's all muddy, and you can really get yourself in trouble if that agreement's not in place, and responsibility for maintenance and repair and whatever else isn't clearly outlined. And we come across it all the time.
Section 98 agreements are going to be talked about a lot more in the advanced course. One trend or one movement I'm seeing recently is the use of call it a Section 98 bylaw, where the terms of the agreement are put in a bylaw. The reason why that's attractive is you only need a majority of the owners to get the bylaw passed, and that creates a public record of the terms. Whereas if you try and do a bulk Section 98 agreement, and you want to do a bulk agreement to reduce the overall cost, the goal is to get 100% of owners signing on. Very difficult. The catch with the bylaw is the bylaw will talk about doing written consent, which is great. The Act speaks of that, but that written consent or that written agreement that reads in the bylaw or the terms of the bylaw still has to be registered on title to the unit. And I'm seeing the bylaw, I'm seeing a lot of condos and even some law firms giving advice that you can do the bylaw and not register the agreements. And I think it's Section 98 sub 4, if I'm not mistaken, which really clearly states the agreement is worthless unless it's registered on title. You just don't have one.
So, so Lorraine's follow-up was, so to confirm, if a Section 98 agreement is in place for those walkways, the question, I guess her position was that if they were being redone as part of the corporation project, the agreement becomes null and void. You lawyers are saying it doesn't change anything if a proper agreement is in place.
If the agreement's in place, the agreement will speak as to who owns the change. All right, so if it says the owner owns the asphalt over the walkway, and the condo as part of its repaving program goes to the owner saying, if you want to repave your walkway, you can pay for it and get it done, might get a break. Well, it's not changing the agreement. The agreement is still staying. Ultimately, the owner owns it, and likely the owner takes care of it.
Great.
But you got to look at the agreement.
So we have a couple other questions. One that came in towards the end of the presentation. We are having a serious issue over the board implementing severe guidelines for opening amenities under COVID. They are not in accordance with regional health legislation. The board is threatening closure completely if residents are not compliant. What course of action do owners have if amenities are closed or in refusal to abide by the imposed guidelines by the board? So sounds like this corporation, the board has gone above and beyond the provincial health regulations with regards to their amenity reopening.
I don't necessarily see that as going contrary to what government is saying. And the challenge with the condo, again, going back to the other laws, the condo is the occupier of the common elements for liability purposes. The condo has to put in place practices and protocols to guard against dangerous conditions. If you have dangerous conditions, you have a breach of 117 of the Act, which you can't have. So the condo's got to put those in place. If it can't get a reasonable comfort level, I think circumstances are still present where a condo could technically keep amenities closed. I think we're all trying to move to open them, but there's got to be those that comfort level's got to be achieved. What have you guys seen on this?
From management experience, so I mean, personally, I've been dealing with this quite frequently right now. I would say at a minimum, corporations and boards are following public health guidelines. And I have several corporations who have gone beyond that. In working with the boards, there's a lot of fear, I think, as board of directors. There's a lot of responsibility put on them to make the right decisions, which is unprecedented decisions for them to make at this time. So, for example, I know in opening a pool at one of my buildings, I believe the original load capacity was 20 people. And public health said reduce that to, best practice would be 25%, but anywhere between 25-50% the capacity for the pool should be reduced. So at a minimum, public health is recommending, let's say 5 people. The corporation decided 2. That was the decision. So, I mean, I think there's a lot of responsibility on the board to make the decision, and they're doing the best to make the safest decision that they feel possible for the corporation. That's just my experience. There's a lot of hesitant board members. It's a lot of pressure on them right now.
Well, one thing to remember also is that you can always, the corporation can always make rules or have requirements in place which are more onerous than the prevailing legal requirements. So that a corporation can always do that, but you of course can't have rules in place which are not in keeping with, in contravention of, or less onerous than the legal requirements, provincial and municipal requirements in place. So as long as the board is making a conscious decision, it may be that they might be, in terms of time, a little behind. Certain corporations might be a little behind as to when they are meeting the step-by-step opening up of things. But as long as they're doing what they think is right, and as long as it's not something that they've jumped the gun and done something before the provincial or municipal requirements are getting there, I think that's okay. That just is to play it safe that way.
Yeah, I have corporations that aren't like gyms were able to reopen in stage 3. I have a lot of buildings that simply are not opening their gyms. They've just made the decision that it's not feasible to do so. So one of the big things as a manager and a management company, one of our biggest kind of general terms is just because you can reopen doesn't mean you have to reopen. You need to ensure that you can safely do so and you're making the best decision for the corporation. So yeah, we got, stage 3 said that we could open the gym on Friday and it's Monday at 9 a.m. and that gym is not open. The board is trying to make a responsible decision, and just because it can doesn't mean it has to.
That's absolutely right. That's I think the driving point, that just because you're able to do something, it doesn't mean that you necessarily have to do it. It's just whenever the time is right for a particular condominium.
It's interesting. Before masks on common elements became mandatory, and it wasn't when municipalities were starting to go that route. Remember, I had discussions with some condos, and there was resistance. They say, we'll encourage it, but we won't put in place, a rule to mandate it or a policy to mandate it. And I always found that a bit surprising. Conversely, going back to the gym or the swimming pool, you got to think that the board is now thinking about how do we deal with touch points or management. Michelle, you're sure you're dealing with this. What are the policies for dealing with all the touch points that are happening in the swimming pool or the gym. It's huge.
Yeah, it's not a rash decision to make. There definitely needs to be a lot of thought put into it, and the policies need to be clearly outlined and written and posted and available for everyone. So it's a thorough process. It's not just slap a sign on the door, open for business.
So one last question. This is a whole topic we could go on. We actually did do one on COVID and construction. We did a condo talk last month. It was on the COVID and construction matters. The last question, because it's already 7 o'clock. This is from Terry. If you purchase washers and dryers from the reserve fund, revenue from the washers dryers should go to reserve fund or general fund? Who wants this?
Sure. It should go. The revenue for the collection of the washer and dryer should go to the operating fund, and the purchase of the appliances should go to the reserve fund. Prefaced by only if you had washers and dryers originally. So if you're replacing existing appliances, it can be a reserve fund expense. If it is a new appliance, that needs to be an operating fund. So I don't think that's something I touched on when I discussed reserve fund expenses and the reserve fund bank account. If it, let's think of a quick example. Security cameras. Your corporation does not currently have a security system in place. That might be a $20,000 expense. Just because it's $20,000 does not mean it's a reserve expense. Because that is not an existing common element asset of the corporation, that is an operating expense. It must be paid through the operating fund. Once it's in place and you need repairs or replacement down the road, it becomes a reserve expense. So I just wanted to touch on that because I didn't talk about that. There are some exceptions. If it's like a code requirement or a safety requirement, it can go through the reserve expense, but most commonly, I just wanted to highlight that aspect of it. Okay.
Well, Michelle and Bilal, as always, it's a pleasure doing these things with you. And I'm sure we could carry on with these discussions and questions, well, for a long time. Have a good evening, and I hope we see a lot of people signing up for the insurance condo talks and the advanced course. Have a good evening.